Good afternoon, Keith Sebo from FRCMedia. Thank you for joining us today. Former Fall River Mayor Jasiel Correia today was sentenced to 6 years in prison on his federal convictions from his trial earlier this year. He was also sentenced to 3 years supervised probation and a fine of $1,300. Judge Douglas Woodlock is going to rule on any restitution in the next day or so. So that's the subplot as we are going to talk about this today. I'm pleased to be joined by, I'll call him our legal analyst, attorney Stephen Sabra of Sabra and Aspden. Steve, thank you for joining us today. How are you?
I'm good, Keith. Good afternoon.
Well, thank you for joining me again, as always. Let me just ask you, before we get into the nuances of things, what are your thoughts about the 6-year prison term and the 3-year probation?
Well, I was a little surprised that it was because I thought it might have been a little bit more. I understand the judge's thought process, or at least his, he said something towards the end about he's visited individuals that he has actually sentenced in prison, and he made a note that if the sentence is over 10 years, defendants tend to lose hope. So I think that kind of influenced his sentence here of 6 years. But also, he added on 3 years of supervised release, which comes out to a total of 9 years, really, where your life is either in jail or incarcerated, and then subject to restrictions. So I think overall he took into account the defendant's youth as a factor, but he made some very strong statements about essentially how bad this was, as far as what the defendant was accused of and convicted of in federal court.
Yeah, I know. Just looking at my notes here from the sentencing, I'm quoting Judge Woodlock here. He calls this, in terms of a crime that is being conducted by a public official, quote, one of the most corrosive crime a community can face. He also said that in the former mayor showing a lack of remorse, and also, still committing crime, even while he was still under federal investigation, not only for the snow owl offenses. He mentioned, quote, this crime in this way is as crude as anything imaginable. So definitely the judge not holding back in terms of his feelings on this case. And, it's important to note, Steve, that, Judge Woodlock, has been on the federal bench for a number of years and has seen a number of these cases come before the court. And he actually pointed out that this is a little different from some of the other, political corruption cases that we may have seen in the past.
Yeah, that's correct. And he mentioned that the defendant showed no remorse, that he was narcissistic, that he took advantage of friends and family, and that he really didn't understand the defendant. He didn't know who he was, because he was trying to consider the nature and circumstances of the defendant in coming up with an appropriate sentence. He said that he didn't understand really who he was and why he did what he did. But he was very strong about the fact that if you can't trust public officials and you can't trust the government, then what do we really have? So I think that although he had acquitted the defendant on a number of those snow owl charges, that was part of his reasoning in giving the sentence that he did. It wasn't just the extortion and extortion conspiracy. It was also the manner that the defendant took advantage of people that trusted him, that some were family, some were longtime friends, when he issued the sentence.
Yeah, I want to get into now what actually happened on Monday, the original date of sentencing. There was, as we had talked about last week, Judge Woodlock started with a discussion on the defense motion for acquittal on a number of the charges, and also motion for a new trial. And Judge Woodlock was really, really concerned that the prosecution did not do its due diligence in terms of coming up with the argument that the wire fraud charges, primarily the depositing of money from the Snowball investors by former Mayor Correia into his bank account, that the prosecution didn't do a good enough job to prove that it was interstate commerce, which brings these charges into a federal realm as compared to a state realm. Talk about that if you can, in terms of explaining that a little bit better, maybe than I did.
Well, no, I think you explained it very well, and even for lawyers, it was a little bit difficult to follow, but that was the gist of it. That the judge felt that there wasn't evidence of the processing of a wire transfer through interstate commerce, and the prosecution didn't really respond to the judge's questions with regard to that issue. I don't think they expected the tact that the judge took, and they didn't look very, very good on Monday with regard to responding to some of the judge's questions. But in their defense, the big issue was this stipulation. So a stipulation means that both parties agree on some fact that is can be an essential element of the crime, meaning that the prosecution doesn't have to present evidence on that issue. So the prosecution felt stipulation that they entered into with the defense, and that was approved by the judge, was sufficient on the issue of proving interstate commerce or in processing of a wire transfer through interstate commerce. But the judge didn't look at the stipulation that way. The judge looked at the stipulation very, very narrowly and ruled that you didn't prove it. There wasn't any evidence of that, even though he kept asking the prosecutors, show me where it is in the record, right? The transcript of the testimony. And they couldn't do that. And that's why he issued this judgment of acquittal on those 6 out of 9 of those charges, those wire fraud charges. And the only ones that were sustained were the ones that were email. And they were able to prove they were emails across interstate commerce. The other charges were all subject to this judgment of acquittal, meaning that even if you take the evidence in the light most favorable to the prosecution, there wasn't enough for a jury to convict on that one element of that crime.
Yeah. And Judge Woodlock also, for right now, as we're talking, also acquitted the former mayor on 2 of the 4 filing false tax return convictions, having to deal with his 2013 and 2014 initial tax returns, because there was some ambiguity there in terms of the reporting of his income. I believe he's still going to be holding a judgment, although he did indicate that he may also possibly acquit the former mayor on the other 2 charges, which were the amended returns for 2013 and 2014. What can you tell us about those?
Well, the issue there was willfulness. So one of the elements is you have to show that the defendant willfully didn't declare income, filed a false tax return, and the judge felt that there was evidence with regard to that part of that element of that charge, and he focused on specific intent, and he didn't see it in the original tax returns that were filed. And then on the amended tax returns, he wavered a little bit. It seemed like on one of the counts, I think it was count L, that he would acquit on that one, but on count M, which dealt with this other company called Snow Chemo, if I've got it right.
Mm-hmm.
And with regard to that one, he was more hesitant. He didn't issue a judgment of acquittal on that one yet. He wanted more time to think about that. So I think we'll see that probably in a written decision tomorrow. But what he did emphasize throughout his comments yesterday was that even acquitting the defendant, some of those charges dealing with wire fraud and tax fraud, it wasn't going to change the sentencing guidelines that judges at least reference. They're not mandatory, but at least they reference. But in that regard, what's important, I think, from a defense attorney standpoint, the defense attorneys were doing exactly what they should be doing, which is you try to knock out as many charges as you can at the trial level, and then you appeal, and hopefully on appeal you get other charges reversed, or you possibly get a new trial on the charges that remain.
He also, Judge Woodlock also mentioned yesterday, I think he brought it up a little bit today as well, that the motion for a new trial, at least one of the arguments from the defense, that he wasn't represented well by attorney Kevin Reddington, who was sitting right there with defense attorneys Fick and Marks. Didn't say, well, had one verbal exchange today concerning a plea agreement, but that he dispelled the charge that former Mayor Correia was not represented well by Kevin Reddington. But I believe there may still be options for the judge to rule potentially for a new trial. And could this mainly, Steve, could come up maybe from not necessarily the defense side, but maybe the prosecution side on those acquittals, in terms of, hey, give us another chance to actually prove the wire fraud across interstate commerce?
I don't think they're going to get another chance. I think the acquittals are they're not appealable, and so double jeopardy would bar him being retried on those. The issue, two other things that struck me today. One was this issue of, was that ever offered a plea deal? And no one was ever quite sure of that, but it was very unusual today. The judge asked directly the prosecution and attorney Reddington, was there ever a plea deal offered? They both said in open court, no, versus what the defendant said after he was convicted, when he made a statement to the press saying that I was offered a plea deal, but I turned it down because I'm not guilty, or something along those lines. So that whole issue was finalized. Not that it had a lot to do with the sentence. I thought it might, but because initially the judge thought that the defendant said again the day before, but the judge was incorrect about that. And the other part of that was interesting along those same lines was, some of us thought that the statement that the defendant made right after he was convicted to the press would come back to haunt him in sentencing. But the judge was interesting in that regard. He said, well, I don't really give much weight to what a party says after they're convicted, in the heat of the moment, which, I give the judge credit, because emotions are high and people say things that they later recognize were ill-advised, so to speak. And then you bring up this other issue of a motion for new trial. So the issue there was whether or not the Snow Owl charges should have been joined together with these marijuana-related charges. And it was kind of a three-step process, basically, where first the issue was, well, did the defendant waive that issue? And the defense attorney at the time, Attorney Reddington, had indicated that they their strategy was that they're okay with both cases being tried together. Then that was addressed further under this sort of term of forfeiture, whether or not, even after the superseding indictment, whether or not the defendant should have filed a motion to sever the two charges, the two sets of charges at that point. And the judge felt that again, it was more of a strategy. And that's when, Keith, you got into that discussion of what's called ineffective assistance of counsel, and his new lawyers sort of moved away from that. But that still kind of, to me, seems to be an open issue, and that's what is still outstanding in this case. This case isn't over, even in the lower U.S. District Court.
Yeah. And, another thing that was talked about a little bit yesterday was, I guess, what happens moving forward. The former mayor has said that he will continue to appeal. I kind of wonder whether that strategy may change a little bit with the Snow Owl acquittals. We'll have to wait to see on that. But there was also talk, maybe, Steve, in terms of the defense asking for a stay of the sentence, in terms of looking at that, and they didn't. The former mayor and his attorneys left the courthouse today without speaking to reporters at all, so we don't know what they're thinking. What are the possibilities here?
Well, two things, right? So the first thing is that the judge gave the defendant time to self-report, and the judge said that in general, the Bureau of Prisons needs about 8 weeks to determine where the defendant will serve his sentence. So you're talking about 2 months from today, where the defendant, I guess, potentially will be incarcerated. Now, the judge also talked about a motion for stay of sentence pending appeal. In other words, if that's allowed, then the defendant doesn't pending a decision on appeal. The judge, in my view, indicated that he wasn't inclined to grant a motion for stay of sentence, but he also gave the parties 3 weeks from today to file additional briefs on that issue and on the issue of a motion for new trial, because the judge is going to have to write a decision on this motion to stay the sentence and the motion for new trial, so that the appeals court can review it. Because let's assume that Judge Woodlock denies the motion for stay of sentence pending appeal, that can be appealed to the First Circuit Court of Appeals, and they may have a different view. So that's kind of one of the next things that's going to happen in this case, and that'll be interesting. It'll mean the difference between whether the defendant goes to jail now or whether or not he stays out of jail pending a decision on appeal.
One final question I want to ask you, and then I'll let you go, is, this has been a locally here in Fall River, a very heavily charged, divisive event for the city. Obviously, it's still not over in terms of appeals and the like. We'll see how that plays out. Just as a resident of this area, how do you feel, the reaction maybe of people? I believe you may get both sides here that will say, well, 6 years may be good. Wish you could have had more. And there could be some people who say less. What are you hearing? What do you think you'll hear, as we move through the days after this sentencing?
I think most people will feel that 6 years wasn't enough. And that could be just general public seems to often want more. And that's really what the judge has to do. They have to come up with their own their own sense of what's a fair sentence. But I think that's that will be the general feeling. But in response to that, I would say it's, yeah, it's 6 years incarcerated, but there's also 3 years of supervised release. And like one of the defense attorneys said in their sentencing memorandum, probation isn't nothing. So you've really got 9 years there. And the judge picked a time that he felt was fair, but he also made a lot of comments from the bench that I think showed that he was concerned about what this meant to the citizens of Fall River. So I think that's the good part of what came out of this, that there is a conviction. The conviction was sustained, of course, pending appeal.
Yeah. All right, Attorney Stephen Sabra from Sabra and Aspden. I appreciate your time as always, and I'm sure we'll catch up as this continues. I appreciate your time.
Thank you, Keith.
All right. And thank you for joining us here on FRC Media. I'm Keith Tebow. Have a great day.